Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Welcome back to Civics in a Year. Today we're talking about the Sherman Antitrust Act, and we have Dr. Sean Beienberg back with us. Dr. Beienberg, what is the Sherman Antitrust Act?
Well, mercifully, unlike many other pieces of legislation, it's actually really short. It's basically 2 paragraphs of substance. You can count it as 3 because they basically restate it for federal territory. And then 4 or 5 paragraphs of jurisdiction and procedural stuff. Like, you could actually read it in like 5 minutes. It's quite nice in that sense. But it's dealing with the problem, consolidation in the American economy that's happening in the late 1880s and early 1890s. So it's passed in 1890. States have been trying to do some efforts against some of these economic spheres, particularly railroads, but these have been struck down both by state and federal courts, sometimes for interfering with federal commerce, sometimes for due process. So the Sherman Antitrust Act is, unsurprisingly, Sherman is the sponsor. This is John Sherman, who is the brother of the Civil War General William Tecumseh Sherman. He had been a Republican during Reconstruction. He's Treasury Secretary for Hayes, then he goes back to the Senate. But there's a real push, and Sherman is somebody who, in this period, tries to be pretty sensitive to public opinion, and he recognizes there's a real strong demand for this. In fact, if you look at both party platforms in 1888, there is language saying we want to basically crack down on anti-competitive behaviors, trusts, et cetera. And so it gets passed basically unanimously. I think there's 1 or 2 negative votes against it in Congress. Harrison signs it. So not that controversial in its spooling up. It gets a little controversial a few years later in arguably its first major Supreme Court case, which is the E.C. Knight Sugar Trust case. And this is a case that is going to see a merger of pretty much all the sugar manufacturers in the United States. Now, they're all in Pennsylvania, so this has a federalism complication. But this company will have 98% control of the market of sugar in the U.S. And so the court actually strikes down the effort to use the Sherman Antitrust Act against this on grounds that the federal government has authority over interstate commerce, not local commerce. And they say this is about regulating manufacturing. And in some sense, this is kind of the lawyer's fault because they'd focused on the percent of manufacturing that the E.C. Knight Company would hold rather than the effects on sort of national prices. Strikingly, John Marshall Harlan, he keeps coming up, but he's not just famous for Plessy, but I think he's a really influential, important justice in this period. He says, look, obviously the feds can't regulate local commerce. I love federalism. There's paragraphs and paragraphs of that. But he says, look, this is a massive sugar company that will literally dominate the entire national market and is by definition interstate commerce because it will be the entire market and states will be unable to deal with it. And so the Sherman Antitrust Act seems like it's potentially going to be kind of limited early on until it gets sort of revivified first by Roosevelt and then especially Taft. So that's sort of the backstory and early lead up to it. I'll talk more about the case law in a second.
So for people who don't know, what does antitrust mean, or what is a trust?
Right. So a trust is effectively a combination. It's effectively a combination of business that is designed to basically consolidate stuff. I mean, I can literally read the first paragraph. It makes it even clearer in some sense than the language. So Section 1, every contract, combination in the form of trust. So a trust is just basically like with stocks or so common holding companies or something, or otherwise, or conspiracy and restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. So again, basically contract combining, organizing your business in a form of a trust or creating another kind of conspiracy in order to suppress trade. That's effectively what it does. And then section 2, every person who shall monopolize or attempt to monopolize or combine or conspire with other persons to monopolize any part of the trade or commerce shall be guilty. So again, it's basically just an effort to suppress anti-competitive practices, whether that's formally merging or de facto merging your companies kind of in a trust, or creating contracts that are basically anti-competitive. Like, we agree we won't charge particular rates or something along those lines. So hopefully, does that sort of explain the basics of it?
I feel like that's been in the news a lot lately.
Yes.
Too,
yeah,
with all of these companies combining. So maybe for our, younger listeners, it would be like if there was like Coca-Cola bought every soda manufacturer out there. And so the only soda you could buy was from Coca-Cola. That would be against this, right?
I mean, in some sense, the closer analogy, because you could still drink milk or orange juice or coffee. Right? So a lot of the pressure from the antitrust is particularly things like railroads, which are basically an economic choke point. So the closer
So there's no alternative.
Yeah. So like the closer analogy would be if basically Amazon bought out Google and bought out, I'm trying to think of all the other companies. They all have been bought out anyway, but if basically, if effectively all of your internet companies were effectively merged, that's closer to what the analogy would be. So particularly, and this will kind of preview when we talk about populism in other podcasts, but the concern is anti-competitive behavior in general, but really the strongest concerns are about railroads and other kinds of economic choke points like that. Something that functions closer to a utility, right? Like if you decide that you don't like Coca-Cola, you could go to Pepsi. But maybe in your example you had, if Coke bought Pepsi, again, you can drink orange juice. But you can't just say, well, you know what? The railroad screwed me over. I guess I'm just going to throw it on a donkey and, walk it across country or something like that, right? But there's not a sort of equivalent that you can do. So again, this is why the focus really is on anti-competitive behavior. And this is something that sort of just foreshadows the populism discussion for one of the other podcasts, but this isn't particularly like a proto-socialist thing. These are basically people that think this is an evidence of market failure, draws on Adam Smith's concerns about monopolies, right? So this is partly why it's so popular, is that it has this like streak that picks up, from the founding. Andrew Jackson really popularizes it, and both Republicans and Democrats pick it up. That there's something, we didn't like the East India Tea Company when it was a monopoly. We don't like that's sort of in our political blood that we don't like monopolies. We do like competition and markets, et cetera, which is why, again, you get basically unanimity from left, right, like pro-capitalist people are pretty into this too. So what's the takeaway from this? Like I said, it tapers off for a few years with enforcement, particularly. I mean, it's not completely unenforced, but it's not seemingly as powerful as folks had hoped it would be. Theodore Roosevelt, when he becomes president, basically says, all right, let's try to revivify these. So there's a couple of cases that I think are worth pointing out that are politically and historically important. So the first one is the so-called Northern Securities case in 1904, which is basically an effort by railroad barons to create a holding company that will run 3 railroads. So they're technically their own railroads, but functionally they're going to be run jointly. And this would particularly dominate, based on where their lines are, this would pretty much completely dominate the Western Railroad network. And so Roosevelt has his Attorney General, Philander Knox, move on them, and they win. And then they move against meatpacking in Illinois, particularly. Now, this one's complicated because that E.C. Knight sugar case I mentioned said we can't regulate stuff that's local economics. And they push in this one, they say, fine, yeah, the meatpacking business is, in this case, mostly in Chicago or something like that. But it's a choke point for the entire national market of beef, basically. And so they say, look, this is not because we don't care that it's, we don't want to regulate like a local grocery store, but like the again, choke point is, they don't use that term, but conceptually is what it is. It's something that's going to dominate the entire market. And so the Supreme Court kind of de facto overturns that EC9 case, or at least they limit it and they say, yeah, we can regulate a business that's operating even in one locality if it's basically going to completely dominate its relevant market. And so in that case, they allow regulation of meat packing, which is obviously something people have been worked up about because of the muckraker journalism at the time. And that's a unanimous case, a unanimous Supreme Court case. And then probably the most politically famous one of this era is the Standard Oil case, which breaks up basically the oil monopoly. And so they strike it, they break that up, although obviously it's now recombined. Like Exxon is like 4 of the parts recombined and later. But the striking thing about this case, though, and this is why it's a very, very long opinion, the court, and this will get kind of technical con law, I'll try to simplify it. They endorse what's called the rule of reason. And this is a doctrine that's floating around in the lower courts that is attempting to kind of synthesize the various antitrust precedents. But basically, this says that there's a difference between consolidation with bad effects for consumers, it's unreasonable, and consolidation with good effects for consumers. And Harlan protests and says, it doesn't say in the language every contract combination in the form of a trust in restraint of trade or commerce that we don't like is illegal. It just says the sort of anti-competitive stuff is illegal. So the Supreme Court adopts that framework, and that largely maintains that to this day, that they distinguish between sort of anti-competitive stuff that effectively the metric they end up later adopting is whether it makes prices go up or down. So if it's a monopoly that lowers your prices, generally they've said this is fine. If it's a monopoly that increases prices, generally it's not fine. Harlan protesting that is one of the very last things he does before he leaves the court. And that's a doctrine that William Howard Taft sort of puts it together when he's a judge, but it's one that Theodore Roosevelt really, really firmly endorses. And this will sort of foreshadow a split he'll have with Woodrow Wilson. Roosevelt is not against bigness, against large scale. He just wants basically the federal government to be even stronger, to push around anything that is sort of large and against the public interest. Whereas Wilson originally will say, no, we want closer to the old school Jacksonian, make everything small. Fed smaller, businesses smaller. So that's sort of the division about decentralization foreshadows a split there. And then the last irony here is that although Taft spells out that rule of reason, when he's president, he's still a really aggressive antitrust. He's even more committed to it than Roosevelt. He issues about 2 times as many. Well, he issues about as many in 4 years as president as Roosevelt does in 7 years as president. So about double the rate. And so that's why he's baffled when Roosevelt says Taft is a tool of big business and a stand patter, and he's letting evil corporations dominate the world. And Taft's like, what are you talking about? I did this as a judge, and I'm doing it more as a president. But it's not the first time that Taft and Roosevelt will squabble, or Wilson and Roosevelt. So preview of more to come.
So would it be fair then that Taft should have the title of trust buster and not Teddy Roosevelt? Because I feel like when we talk about American history, like that is Teddy Roosevelt's things. He is the trust buster. But now I'm hearing maybe it was Taft.
So Roosevelt sort of reinvigorates enforcement after it looks kind of weak. So he sort of gets the ball rolling again. But Taft is certainly more aggressive than Roosevelt is. And people at the time note that. Historians now note that. But I know you are very keen on Roosevelt, but his flexibility with portraying himself and other people is notable. So don't necessarily believe branding that you hear from Theodore Roosevelt.
I like to study him. I think that he is a very interesting president to study. I've been very careful with my questions as I interview people of like, I'm trying to get away from like, who's your favorite president? Like, who is your favorite to study? And Roosevelt to me is just so interesting.
Oh, absolutely.
To study. But now I'm like, I also think William Howard Taft is pretty cool because he became a Supreme Court justice. Like, who does that? But now I'm like, is Taft the real trust buster?
Arguably,
that might be a great argumentative prompt for a classroom. Is the Sherman Antitrust Act something that people should know today? Is it still relevant?
Yeah. Oh, yeah. It's still basically the Sherman Antitrust Act. They sort of bolt some pieces on in 1914 with the Clayton Act, and there's a subsequent statute in the 30s, but it's still the basis, basically, of antitrust law today. They're still discussing that rule of reason kinds of question. So, yes, it absolutely still matters. Lawyers still fight about sort of it and or its recodification, but its basic principles still govern the architecture of antitrust law. So, yes, that is definitely one to know, not just because you're a history nerd. It still matters, and they still squabble about it. And every time there's debate about who are we going to appoint to the FTC commissioners, is often attached to a lot of these kinds of conversations too. So yes. And as you were alluding to earlier, we started all the discussions about the Warner Brothers mergers is still basically all framed along the kind of language, the conversations we're having about that would look recognizable to the conversations that they were having about the Sherman Antitrust Act in the 1890s.
Right. Well, now I need to do some more research on William Howard Taft. So, Dr. Beienberg.
Always a good problem.
Yes, Dr. Beienberg, thank you so much.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.